Sir, a very good evening to all the participants and welcome to the week 2 lecture of the Know Your IP lecture series, which has been started as an initiative of the DPIIT IPR Chair, Osmania University. Now I request the IPR Chair Professor G.V. Reddy Garu, to please chair the session. Thank you, sir.
Thank you. Thank you, Dr. Irfan. Uh, very good evening to Sai Bhavana,
Thank you, sir.
Mr. Srinivas Rao, and all the learned participants. Uh, at the outset, I wish all of you a Merry Christmas, and we are happy to, uh, in fact, join with you in this second lecture in the online lecture series organized by the DPIIT IPR Chair of Osmania University. And in order to interact with you and to, in fact, clarify some of the most common doubts in the area of intellectual property rights and internet, we have with us Ms. Sai Bhavana Vemuri, who is a practicing advocate and independent researcher, and who is very passionate about the intellectual property rights and technology. And this topic has been chosen to, in fact, for the purpose of interaction in view of the increasing importance of intellectual property rights in the digital era. So right from internet copyright to patenting of computer programs to artificial intelligence, the resource person is going to take you to different places and to demystify many of your impressions, or maybe learn in helping in learn, unlearn, and relearning some of the aspects. I don't want to stand between you and the resource person, but before that, I have the pleasant duty of introducing Ms. Sai Bhavana. I have had the privilege of working with her on few papers. She helped us in publishing a few papers. She herself published a number of papers on intellectual property rights. She has done her BA LL.B honors from National Law University, Vizag, which is DSNLU right now, and LL.M with specialization in intellectual property rights and technology laws from OP Jindal Global University. She is an advocate and independent researcher based out of Hyderabad, and currently she is working as legal associate with the chartered accountant Sri V. Ramachandra Rao and Associates, Hyderabad. She has been a research associate at Lakshmana, Chary and Associates Advocates, Hyderabad. She was also a research assistant at MHRD IPR-Chair at IIT Madras, and she has authored various articles and published in national journals, including an article with yours truly entitled Discussing IPR Issues When AI is the Author, a Birdseye Perspective, which was published in a prestigious IPR journal in Kerala. She was a gold medalist in the subject, in many subjects, in fact, legal methods, law of torts, history, and sports law during the course of her BA LL.B honors. And she has achieved the highest grade in European competition law research conducted during her LL.M. Sai Bhavana is currently working on music copyright laws, while also actively involved in filing civil and criminal lawsuits and fighting for environmental concerns. So I extend a very warm welcome to you, Sai Bhavana, on behalf of DPIIT IPR Chair, Osmania University, and all the organizers and participants. Over to you. Thank you.
Thank you, sir. Thanks a lot. It's actually an extremely pleasurable occasion for me also. I'm really glad you've asked me to, host this session. Like we discussed, and like I want to inform all of the participants as well, this is going to be a very brief introduction. I'm going to be Sir has already in the first week talked about IPRs. He has discussed in depth about copyrights, trademarks, and patents. And he has also talked about Designs Act and the others. So he has very precisely mentioned the necessities for registration, how long does the registration exist, and all the others. So I'm not going to be dwelling into introduction of those. I'm going to be dealing with how do you link that with internet? Where do you look for on the internet when you're surfing the internet? Where do you look for any of those? And yeah, so I think I'm going to be just doing a brief of all of the different areas of IPR and how they interface with internet. Discussing internet's effect on copyrights, trademarks, patents, and vice versa. So the reason this, the reason we're stuck in the title is because that's where everything begins. How does copyright, trademark, and patent affect internet? And how does the internet affect all of these three areas? So internet per se. We had internet by 1960s around the world. However, to India, we, I think, started off in 1995 or around that. We were still at 10,000 users in 95. However, currently we've gone, beyond all metes and bounds and expectations. There is an internet connection with almost everybody now. And there was a point in 95 where we actually started using internet through the telephone or cable connection. So the cable connection is connected to a modulator, that's a modem, and the modem is then used, like the modem is connected to the computer. And yeah, so analog signals which pass through the cable go through to the modem, they change into digital ones, bunch of ones and zeros, and yeah, that helped us see everything over the internet. Like we said, it's changed quite a bit over the years, and because of all the changes and all the various ways internet is used right now, the necessity to develop IP laws over it also has, taken up. And yeah, so before we start up with IP, what copyrights per se or any other IP that are not existent in any of the internet or web services that you use? So to rephrase, is there any internet service that you can use where there is no IP's involvement, there's no intellectual properties involvement? So ponder over that and send in some replies, and maybe after the end of the discussion we can go through and maybe you can surprise me. Yeah, coming back. Copyright, however, you see it everywhere. There's music, pretty much the artworks, right? So from all the social media that is used by most of this generation, and the non-social media, the browsing of internet in general also, most of what you see, what you read, everything is copyright protected, because like we all know, the Berne Convention has stated very clearly that everything that is written for the first time, everything that is done for the first time, which is liable or eligible to be protected by copyrights, is protected irrespective of the registration. We will later on see that registration does make a difference, but irrespective, it is still a copyrightable material. So yeah, other than the overuse of copyright, of late we have seen a development in trademarks and usage of trademarks over the internet. Domain name, which though technically isn't supposed to be considered as a trademark, like for example, google.com is the domain name. So you wouldn't call it a trademark generally, but over the internet, because domain name is what will link a person to the place of business, it is of late been used, synonymously with the trademark. And yeah, it has been held by the Bombay High Court that domain name is the internet equivalent of physical terrestrial address. So that is also protected. And that also, if it is used or if it is misused, is liable to be, it is a punishable offense. To discuss IPR over the internet and to understand it better, there are two different perspectives that we could approach it from. We'll do both of those. We'll start with internet, how internet revolutionized IP, that is intellectual properties distribution, and the benefits and the issues that it has. The second is, how did intellectual property change as a part of increased internet's usage? Because if you recollect, IP was created to protect the rights of inventors, as in creators, back in 1800s by the British, by the Queen, just so that there can be a publishers guild, or the printing machine that was invented has actually, that's where it is, most of the copyright wheels were set into motion. But because internet blew up all of it and copying has become very easy, IP also had to change, the amount of internet we use has changed, the amount of ways IP has changed too. So we look at all of that too. Yeah, so the first thing most of you guys know about internet is social media. Again, we'll come back. So social media, it is very easy for us to have anything published on a social media. For example, if you click a picture earlier, by earlier I mean go back to 1800s. Let's say you had a picture, you painted something, or you created some music, you created a new recipe, or anything creative. For it to get into public knowledge, for it to be known to people, it took a lot of time, because there was only a limited amount of resources that could be used to take this new knowledge into the public. However, because of internet, there's no stopping of where this information could lead. Everything that you need is almost there at your fingertips over the internet. You want a book from Oxford Law Library, it's available, and most of them are scanned and preserved timelessly, which is a very good benefit. But publishing all the IP we have definitely has its own dangers too. So the dangers of publishing all the IP we create over internet. There's a very little space between what you create and where you show it. So you click a beautiful picture, it goes on to Snapchat, Instagram, Facebook, WhatsApp, and of late there is a live streaming mobile application where you're seeing something beautiful, a sunset, you're ready to show it across to the world. So because the space between the creation and publication of the work has reduced, it is a benefit for the creators, but it is a very problematic issue for everybody else on the internet looking at it, because you don't know the ages of the people on the other side of your screen. You don't know, it's mostly unaccounted for, the information you create. What if it is harmful? What if it creates terroristic perspectives in people? You don't want to start a war. So yeah, all of these are the basic differences that are existing because of how easy it is for you to get onto the internet, make your voice heard, and which is a great thing, because freedom of speech on one hand has been which has been subject to a lot of women or whoever. They have been subject to a lot of pressure, and they have been subject to a lot of issues and not been allowed to use the freedom of speech they have. But because of the internet, there's no stopping. You get kicked out of a website for some reason, like Twitter and most of our celebrities. You come back with a different name and you're ready to talk again. No, there's no stopping you. So yeah. Again, another issue, ununiform laws. Because internet is so global, and because what you share goes around the world, it is pretty much impossible to be able to have an equivocal statement about what you protect from all the different governments. By that I mean, you cannot have a single voice, or you cannot have a single protection format for all copyright, trademark, or all the issues around the world. Because again, coming back to Berne Convention, it does say that you're allowed to create your own laws and have your own regulations. However, when you are a signatory to the Berne Convention, you are only protected, your rights are only protected to a certain extent. That is, for example, artistic rights. The Berne Convention doesn't protect multimedia rights, but moving ahead from there, you became signatory to another convention which allowed you phonographically improvised version of all the creativity. So like that, the law can only take steps trying to cover up what you've probably done as a mistake. So internationally, irrespective of how developed India gets or the other countries get, internationally, to get a regulation, you're going to have to wait until most of the countries make the same mistakes you do, and then you're almost on a similar footing. Only then will they come back to pat their backs and think, okay, let's make a law to have all of it in order. So that's another issue. Publication costs are reduced. So by that, I mean, it's pretty easy to be creative in this day and age than earlier. And it's easy to get your work around the world in a single click or more than that. And, it doesn't take the amount of effort it did earlier. So how did IP enable you to use the internet better? That's a pondering question. How did copyright over the internet evolve over the years? For that, let's start with what you're doing, you and I right now. We're connecting through a medium which for us to see the copyright in what you and I are doing. So we begin with the medium we connect, Google Meet, yeah, and all the other such online interfaces. All of them are publishing information which is copyright protected. I'm giving a lecture which is again protected. It is something I'm uttering for the first time, and I've made notes for it, and I've put in enough effort. So it does qualify as copyrightable material. And I'm connecting to you through the internet, which uses an ISP, Internet Service Provider, which is my internet service provider, through Google. And on the other side of it, you have the same sort of internet service provider and another device. So the easier it has become for information to transfer and transmit, the tougher it became for this entire chain to be protected. Because in this situation, we are doing a copyright class and discussing something that is, not really a harmful information. But if there is a harmful or protected information that is published from one end to the other, where both the countries where it exists, in the country that it is starting at, like from my end, let's say, I am allowed to talk about certain information, and you are placed in a different country where you're not allowed to see it. So though it passes to two channels where what I am doing is legal here, but what you're doing on your end is not legal. So these are, the kind of questions that have developed because of copyright, and that's what we plan to answer to. And one of the cases initially that we can look at is photographs by Playboy. So they had various photographs, 170 photographs, and they appeared on BBS, a bulletin board service, which had no authorization to publish any of these photographs. Yet they published it on their website, and it has reached numerous people. So Playboy has approached the court, where the court has said that the said BBS service, whatever it is running, was infringement. And the similar cases can be seen, time and again around the world. Now that we know there is an issue, how can it be enforced? So for enforcement, again, copyright is very particular about what is a material that is published. To be published, there are certain stipulations that you have to understand, which is the threshold for it to be considered as publication. So for a copyrightable material to be considered as published, it has to be published known to the people that it is intended for. It has to go into the public domain, and unless that can be proved with internet also, it doesn't fall under the purview of a questionable issue. UTV was UTV's case, which is held by Delhi High Court. So we all know UTV. It has, I think, lately has come up with a Hindi channel also. Other than that, they are into media, production of media, which is multimedia that involves movies or series or serials or different kinds of that. When they did create some movies and some other multimedia, it was published on different websites where they knew 30 of them were identified, and there were quite a few unknown defendants. So we have known cases of John Doe orders being issued, but this is one of the most recent. It happened in 2019, like the most recent case. And yeah, it has kind of changed the dynamics of intellectual property and the enforcement of copyright, specifically in India, because giving an order against a known defendant is something that our courts are known for, but we also have John Doe orders and Anton Pillen orders, but the kind of injunction that was given by the court in this particular instance takes it a step ahead. So yeah, a UTV filed case against 30 known unknown defendants and other ministries, and this case was heard in the Delhi High Court. What was considered as questions in this case, which had to be answered by an amicus curiae, were if an infringer of copyright on internet is same as the infringer on a physical world. By that, so let's say you copy someone's work physically. It could be a painting, it could be some artwork. If you physically copy it, that is different because you're showing it around and you're selling it, and that's when it becomes punishable. But if you're putting it online, how much of a difference does that is existing? How different is infringement physically, and how different is it for the internet? While some of the defendants did claim that it is different, and in the online world there is no money, is what they said. But the court answered this negatively, stating that copyright over the internet is exactly same as the copyright in physical world. Yeah. Then the second part of it is website. How can a website which is making a piracy and which is showing pirated videos, can it claim free and open internet? And yeah, is blocking of that allowed? So firstly, if a website is publishing some information that is copyrighted and it is not per se allowed to publish it, then it is already the wrongdoer. Blocking of such a website, is that against free and open internet, is the question here. So you're already doing a mistake and you're claiming that you have rights of free and open internet, and that's why you're doing the mistake. So of course, the court has said that it doesn't work that way as well, and the opponent cannot claim free and open internet. And blocking of a website does not make the court's decision. Yeah, rogue website. Again, this is a term that we are using, but the court there said flagrantly infringing online locations. What it means by that is there are online locations which create only infringing information. So these websites are particularly doing the one work of creating or disseminating information which is copyright protected, which is infringing someone else's rights. So those are called rogue websites. The court did not dwell further into what other could be considered rogue websites and all of that, but it did consider two separate cases about qualitative and quantitative determination. Now, why is that important is, if you don't know if the website is rogue or not, you cannot ask for it to be taken down, which is of course a problem. So to determine if it is rogue, you have to know if you have to go through the test. While the quantitative test was set up, was taken from the Bombay High Court's judgment where Eros has filed against BSNL, saying that Eros International makes movies, and Eros International's movie was displayed over some website, which I think the ISP was BSNL here. So yeah, the Bombay High Court here did not grant the John Doe order. However, it said it has given considerations that have to be taken when you have to pass blocking orders. So these were pitted against the qualitative approach, which again, the Delhi High Court considered its own case, where overwhelmingly infringing websites were taken down with the John Doe order. The defendants posted videos and posted UTV's copyright protected content over their website. So of course they fell under the category of rogue websites. And if the court is correct in passing orders to block such websites, of course the court passed an affirmative on that. And coming on to the most interesting area of this case, once the court has passed this order, it is noticed that each time there pop up another couple of websites with the similar content. That's why there are unknown defendants. So let's say Google.us is the US domain, right? So let's say you block that. There pops another Google domain which is registered somewhere else, and you can use it, for similar function. So that happened with this rogue website, and each time it was blocked, they either multiplied or they resurfaced with a different, entity as a different entity, or it was mirrored to a different entity, and this kept happening constantly as an issue. So the court in this case, this was the first case where it has given a dynamic injunction in India. Moving ahead, we will see that it was given earlier around the world called global injunction, I think in Canada. But for India, at least, this is the first case where dynamic injunction was passed. And like we can have it, the injunction, again, to enforce the injunction, because the court already has enough burden, enforcement of it, and to have each time a new website pops up, you don't have to go to the court to apply for it once you get this injunction. For the Delhi High Court, at least, and for this case, I think the court, there was an established principal secretary of the court, I think, who was given the right to decide over further instances of interference. What is public and what is private use? Because private use of copyright is protected under the fair use doctrine, where when it is used for purposes of research or purposes of self-pleasure, or for people in the house, or any of these are allowed as private use. But if you publish it to people, that amounts to piracy, and that is what is punishable. So yeah, in the case of CIT versus Oracle, the couple made a CD, and they had a CD which they purchased, and they pirated it at their home and made multiple copies of it. So that was held to be piracy, and of course violation of copyright. Temporary copying. Cache is information that is saved by all of our phones and laptops and all the electronic devices, where when you browse something, there is certain information that though you don't have to see, that though is not displayed over your screen, it is stored by your computer to make that screen function. So caching saves a part of the information in the device, but it's not always usable. But saving is, this issue is called fixation. Fixation of where is this copyrightable material fixated is what changes how you look at the law. So if it is fixated on the CD, though information on the CD is protected, fixation of it on the CD is giving the whole thing a copyright protection. So temporarily saving information on your mobile phone could be infringement, or it could not, because though we don't have set rules about it so far, we do have similar rules to look out for. Like in the case of Sanford versus Jackson, this is Michael Jackson. So in one of his songs, Please Love Me Now, Sanford was one of the singers of, I think, 2000s, and he claims to have made a CD with one of his songs which sounded very similar to Please Love Me. And he goes on to the court to discuss, to prove to the jury that he has in fact made this song by tapping his feet, clicking his fingers and all of those, and he's recorded them on a device which is played in the court, and then later on, an instance of infringement is decided upon. Hyperlinking and meta tagging. So with copyright being, with websites getting the option of being copyrightable, like what you see on a website is copyrightable, right? So let's say you're seeing the Google website, but it looks the same, but the domain is changed to someone else's, to a different domain. So you are seeing, you are browsing for information regularly. It makes very little difference to you, but it has been hyperlinked over to a different website. So I would be the creator, and let's say a person X would be using the design I do over my website and make a exact similar copy or some sort of a copy and imbibe it onto his website. So each time I go to the X's website, I'll be meta tagged into mine. I'll come back to mine anyway. But before that, I go through a series of web pages for the other person who's created it, and that will give them revenue, but it will cut down the amount of interaction I have with my consumers. So hyperlinking is essential, because without hyperlinking, you wouldn't be able to, it wouldn't be easy to navigate various websites. Like if you don't Google, how are you going to get to what Google Scholar has on internet and copyright, right? So it hyperlinks another websites to you and gives a list of it like a database. The database is protected. The hyperlinking is legal most times, but not all the time. So if the hyperlink is put way into the original, or the original website is put into the website you're accessing now, after layers and layers of other websites, then the hyperlinking gets tricky, because the copyright information, though, is coming from the original website, you're not really seeing it from the channel you're supposed to, which creates trademark and copyright issues. So there are three major issues that are caused by hyperlinking. How deep is the pages of website? Like this link is how deep is it buried into the other pages of the website? The deeper it's buried, the tougher it will be to get there, tougher it will be to get the right information, and that causes a series of issues, not only copyright wise, even otherwise for the person. Be confusing. So if hyperlinking is done and it's done legally, like how Google does it or like how YouTube does it, that would still not violate. But if you access it, and if you are using trademarks from other, or the primary website, then that would be a violation. How such information, while linked to another site, is presented to internet users. So let's say there is an article about gun laws and the protection per se, but it is hyperlinked for a channel which sells guns. So you would be going to read about gun laws. You'd open a website, you're reading through gun laws of the US, UK, and all of that. There are multiple hyperlinks that are present there, and despite you not knowing, you get into one of the hyperlink. It'll take you to a website that actually helps you buy a gun. So that is the issue. So that's the third point here. It says when when it is presented in the right frame of mind or right frame to the person accessing it, it could be used for better benefits. While if it is not, then it creates issues. Digital Equipment Corporation versus Alta Vista Technology. So here the plaintiff had actually okay, so the plaintiff, the Digital Equipment had a search engine called Alta Vista. So Digital Equipment owns ATI. ATI purchased trademark rights of Alta Vista. It's a subsidiary company and they held all the rights. But Digital later licensed back all these rights to Alta Vista. And so, of course, the domain name also moved. However, Digital went to the court saying that ATI was infringing their trademark license agreement by using Alta Vista for themselves and not sharing it, like not being, and for Digital for not being able to use it. So yeah, because Digital had the trademark, it got a preliminary injunction in its favor, and of course the licensing agreement helps as well. Framing of a website is pretty similar to hyperlinking, meta tagging. So framing is you have content of your website. Your website has some content, gun laws, and you publish it on another gun selling website. Just that you don't do it by yourself. This frame is set into that, and you are seeing the website which sells guns, but just in a different frame. So yeah, framing definitely involves both copyright and trademark issues. When you're using it, you could be one of the violators. If you are creating it, you can be a violator. And if you're using information for which you do not take permission, that again is a violation. In this, with respect to framing, the most important case here is Ticketmaster's. So Ticketmaster is a website which has exclusive rights to sell certain tickets. And if you go to its homepage, it used to have the website. The website had all the tickets they were allowed to sell, all the other events that are happening, all the other information about it, and how to use the website, how you could buy tickets through that website, or how you could buy tickets otherwise, and they could sell it to you. That is like, if you purchase them on the phone, they will send it to you in courier. So they had all of this information. And there was a rival website called Tickets.com. Notice how very similar their domain names are. So Ticketmaster.com and Tickets.com. So yeah, Tickets.com hyperlinked and put Ticketmaster's webpage as a frame to its own website. And so here Ticketmaster has filed saying that it interfered with their economic relationship with its advertisers, with its consumers, with all the people that accessed the webpage, and with the people from the concert that it was selling tickets to. And so the judge in this case, though he did rule that hyperlinking does not involve violation, but yeah, it is supposed to be implemented based on every situation, which is why it is always better to seek permission before hyperlinking or framing another's website. Registration of copyright. I think in the beginning of this, we've spoken about registration of copyright. So even like how GB Reddy sir has said in this first class, it's not necessary to register a copyright. So there's no compulsion. The act doesn't prohibit you to use your work if you don't register this. There's no sort of necessity for it. But time and again, the court has held that if you do not register your copyright, you cannot ask to enforce the remedies that it provides. So there's no mistake not registering, but there's no way you get to enforce your rights if you don't register it, which happened in this case, and likewise has happened in numerous cases ever since and before also. India is generally considered to be a culturally different country. We have numerous cultures. We follow almost all kinds of religions possible, and we have different religious and cultural restrictions. We have imbibed some of it in the name of dharma also. However, because copyright is available through various countries, control of such content is very minimum. So if you had a book that you didn't want to publish in India, or if you didn't want that book to be sold in India, there was control over it, like the Press Trust of India could control what was published, or the news that you listen to. There can be control over it because it goes through a source. But because everything is online, and if there is information the nicest example for this, I think all of you will remember there was a certain army. I think he was a commander or something, who was caught and who was in Pakistan during that Pathankot firings. But they made it a news in South India because he was a South Indian. He was from Tamil Nadu. His wife was here and all of that. So all the information that wasn't supposed to get to Pakistan could reach because of all the internet communication that was available. But let's say you remove internet out of the situation. You don't want such certain secure information to reach across the borders. Without internet, it would have been pretty easy. So the biggest question with internet and copyright that you have to look forward to, that you have to prepare to answer, would be how can such communication be controlled, or how can such communication be validated before it is passed on. So if there is a mechanism to go through and to see what you're posting, what you're doing, and for it to get validated before it gets out into the public, that would be a great mechanism. But how can it be done when there are numerous users and there are numerous loopholes to the existing internet usage? That's the point that most of you as young lawyers will be addressing most of the time. Instagram, Facebook, and Twitter. If you go to see, most of them have this addictive format where you scroll through. So once you start scrolling, you're just up there. You're scrolling for numerous hours. But most of the time, what I didn't realize when I used it, and what most of you don't realize now, would be the amount of copyright violation there is in all of the social media. Also, one other very tricky thing is there also is a lot of authors do get their credits, especially on all the social media sites. If you post a picture that is not yours, that was clicked by a famous photographer, and you don't tag him, if not the followers that see you, the outsiders that see you can also report about it. It's a feature on Instagram. It has helped numerous artists so far, and I'm sure it's still doing a good job. The same follows with Facebook and Twitter. If you post something that does not belong to you, and though the consumer also is not a regular consumer of the same information, they can still report it. They can still that same issue will get resolved after the guidelines, like basing on the guidelines. Instagram, Facebook, and Twitter have their own separate guidelines. So basing on what mechanism they have, they check through your queries, and that's when the same post is reinstated. But the biggest problem that is developing so far, and because of COVID, is live streaming applications. So just before 2019, probably by 2018, live streaming had started, but it wasn't used to the extent that it is used today. Like, because we're all stuck at home and we've all been through numerous lockdowns, live streaming has helped most of us get through different phases of it. Let's say a cricket match or a football match or a performance is live streamed by a mobile phone. It's not even an example because it has happened so many times. So for enforcing control over such very tiny area is impossible, because there is a stadium with about 3,000-4,000 people there, and each one of them has at least one phone. There could be numerous amount of them live streaming at the current moment. In the UK, for Metallica concert or one of those concerts, if they had the option to block all the internet services around the area for during the period of the concert, that was possible because it was UK. It's not as easy in India because we have other issues to fight with. Other than the IT and IP laws, we also have to answer constitutional laws. Whereas in the UK, I'm not saying there are no constitutional laws, there are, but it's much easier to get an order there to restrain 3 hours of internet activity for a certain area because it is prone to be live streamed. There was a very famous boxing match that I remember, which was live streamed lately. Forget to recollect the names, but maybe by the end of the session, I'll remember and give it. Yeah, so that's live streaming is another area you have to look forward to. Copyright violation there comes because the performers have a right, like Sir has discussed. Performers' rights are relative rights which are attachments to copyright laws. So though it is not set in writing, performers also have a right, like the cricket players, all the players have rights. Same with football or with dance or with any of the other performances, like a show, like a somebody doing, what is it called, like a show. That also all of the performers have rights. So if you're publishing it without their permission on a live streaming mobile, there is a definite violation. The only bigger question here is you cannot have all of these be controlled by the mobile application. So I think Bingo Dingo, one of those was the name of the applications earlier. The app can only do a little bit. It will channelize maybe 100 users from showing such protected media. It cannot do the same extensively for everybody. With 3,000 people in a stadium, you can't expect one app to control all the 3,000 live streamings. One stops, the other starts somewhere else. So the bigger question here is there another medium to have control over it, control over such live streaming, unauthorized live streaming? So so far that I see, I think control, giving it to internet service providers by Information Technology Act was in a way a good step ahead, because an internet service provider, let's say, is providing service to about 5,000-6,000 people. He does that on a regular basis. There is easier way for him to monitor such amount of users regularly, so he does the same every day, right? He's got 6,000 customers. He looks at the 6,000 customers every day. He doesn't have to particularly look at what you're doing. Again, I'm not suggesting that there could be a violation of freedom of speech. But what I am suggesting is the internet service provider has the accessibility. He has the amount of necessity to have control and to look over the number of people using what they're using, because they are his customers. That's what he does every day. So control from ISP side could be doable, but not in all instances, because there could be instances where the ISP might not be able to track the user because it is going through a series of ISPs. Again, that's a question that only time should answer. Next, YouTube. YouTube is one of the most, it is the pioneer in how we see videos or how we've used the internet, because it was one of the first websites that came into being after the World Wide Web. And and it has a very peculiar method of enforcement of copyright. See, YouTube has its own rules. It follows all the copyright rules of different countries. It has to, because otherwise they can't function there. So wherever YouTube is allowed to function, they follow all the rules there, but they have their own set YouTube guidelines. So in the case that we're seeing here, Stephanie Lenz versus Universal Music Corporation. So Lenz made a video of her son dancing to a song, which is published and which is the property of Universal Music. However, once she uploaded it to YouTube, Universal, not just Universal, but all the music labels have their own control, and they check the number of people uploading the same video, or they check the number of piracies of their music happening. So they send a notice to YouTube saying, pursuant to DMCA, that is Digital Millennium Copyright Act, which is the US, but this is the US case. So pursuant to DMCA, they say Universal's copyrights are being infringed, and so Lens's son's video of dancing has to be taken down. Of course, YouTube complies and they take it down, but after that, Lens sends a counter notice because I think it's a 32-second video. So firstly, there are numerous rules about the amount of time you have to use a music for it to be infringement. Again, we're not getting in depth into it because copyright in music is an area I could probably discuss for another hour, and we don't have that time. So the amount of time you have to publish or use a song for it to be infringement is discussed under various case laws. So 30 seconds of the song would be a violation, but using it and for displaying your own moves on it, because it's the son dancing like he can over the song. So she's not really showing the original song, she's only using the background voice, but the principal interest in her in the video and for her posting the video is her son there. So that is a misrepresentation. So she writes in a counter notice to YouTube saying, how can it be taken down because it doesn't violate any copyright provisions? And so after 6 weeks, this video gets restored, but she goes to the court anyway because it's a case of misrepresentation, and pursuant to DMCA, Universal is not allowed to send such notice. Because DMCA says that such notice should be sent to the copyright, to the copyright creator, that is Lens should have gotten that notice, and any other service should have any other notice should have gone to YouTube. But that was the claim she made. However, the court concluded that YouTube qualifies for protection, so the takedown notice, which was sent by Universal, is valid, is what they said. Then moving ahead, image rights. Very close to this YouTube situation is the image rights. See, in the normal, without the internet era, image rights only represented images that were printed. So a celebrity photo shoot, if you saw it on a billboard, would be a violation of image rights if he's not paid for the picture being there. But with images being so easily available for celebrities or otherwise for anybody, the amount of privacy that a person has, either a celebrity or a non-celebrity, seem to be very curtailed, because you have the rights over your image even after you publish it, but you're publishing it internationally. How will you ever know who is using it somewhere in, I don't know, the middle of Antarctica? Because you've put it out there and they're able to use it. So that's a very it's very tricky to balance both the issues. Then plagiarism. It wouldn't be a complete session if we don't discuss plagiarism. All of your students, I'm hoping, are supposed to write projects, because that was something we had to do in college as well, and the most painful ever. But back in college, what we didn't recognize, what I didn't recognize too, was the effect of plagiarism. It is just putting a bunch of information from that different people have uttered into one place and giving it to your professor and getting done with. That was what projects were for. But the amount of effort each person has contributed for the work that you call yours is immense. So you wouldn't know it until someone plagiarizes your work and doesn't give you credit. Which again brings me, there are different parts of this presentation, which, the words have been taken from different places, and it's not plagiarism because I have given all the links. So Yeah, I'm hoping it helps you do something like that later too. Moving ahead, the Napster case. So there is an MP3 case and there is a Napster case also. Napster is a website which held MP3s, and the MP3 case was a little bit before that. So we'll start at the MP3 case and we'll quickly brush over Napster and yeah. So the MP3 case was where all the songs generally were on the MP3 format because that was the medium where we saved it. That was where the music was fixated for a certain period of time at least. So Recording Association of America, which is called RIAA, has filed a case against mp3.com because this mp3.com has had over 40,000 albums saved on their website, which are eligible to be downloaded and which could be shared or which could be sent from the website's medium. So, and again, all of these were legally the property owned by Recording Association. So Recording Association filed a case, and in this case, a partial summary judgment was granted by Judge Rakoff against MP3, saying that the argument that MP3 had made here was that we are just storing subscribers' CDs and allowing them to listen to the CD at their own time. But in essence, the CD was stored not only in the subscriber's profile, but it was saved publicly also. So everybody has public profile, and you get into their public profile, you could see what's saved there and you could listen to the music. So of course, it was not just hosting different music. It was also the library, like an illegal library that they created for music that they should have originally paid for. So they got the mp3.com in this situation got a judgment against them. Later on, Napster developed, which is the case at hand here. Napster is a software where if you have music in your own computer or whatever, you could put the music on. Like the software allowed you to change your music and put it on the website also. So you had a CD. It didn't have to be in MP3. It could have been different formats. It would change the format and put that format into the website. You can use it. You can listen to it again for yourself, but it is also open to the others, and of course everybody else was using it. So in this way they created a database, again exactly like mp3.com. So however, the judge in this case said that ISPs also cannot be held liable here because they are merely so you connect to the internet and the ISP helps you connect to the internet. Napster helps you change the music. So Napster is the wrongdoer here, not the internet. So ISPs were not held liable. However, Napster was held liable. And because of it, they had to block close to 335,000 of users who posted Metallica's music. Because internet is making everything it's so fast to put everything online, it is not equally fast to get it off online. However, EU, like European Union, has one of the world's most stringent data protection or copyright protection rules. So EU's data protection rules say there is a right to be forgotten, which is in the protection directive, and it says that if a person is if the person is not happy with the information available online, and if the person has necessity to believe that such information is outdated or has changed, has no relevance in the current situation, in all of these situations, that had to be removed. So if I applied saying whatever information is published in so-and-so place is not relevant, it's not necessary, it has changed and it has developed, then the website publishing such information is liable to remove it. So other than the two cases you see on the screen, there was another case I remember reading earlier too. A female who's, she had a public profile on one of the social media sites. And this is again another EU case. So her profile contained information about an arrest. She was arrested and the profile had such information online. Oh no, maybe it was the police station which shared the information. So this website posted information that the police had, the charge sheet, the arrest report, all of those. And later on, she was contending for the position of a political party. And because whoever Googled her could find all of this information about her arrest, a lot of people did not vote for her. So then she approached Google saying this information is outdated, it has changed, and you have to remove it, and all of that routine. Surprisingly, the court here, I don't think, has held that such information is liable to be removed because, see, the nature of this information is that even if she is out of the jail, she's still a convict. She's convicted for it. She was jailed and she's served the term and then she's come out. So her status as a convict might have changed after she got released, but the incident that got her that status remains the same. So, yeah, such judgments are what caves path for most of the other countries, especially for us in India. I think both the cases on the screen now are pretty easy. So, yeah, the Google versus Equistake, the second case that you see here. Basically, there was a device that was manufactured by Equistec who data link. But this device was used by Data Link to connect to internet, and Data Link had later absconded because they didn't want to face the charges. But the information was still available online. So Equistec has gone to the court saying Google had Google could remove all of that information, infringing information. So they did remove it initially. However, it was removed from the Canada website. So google.ca did not have the information that they didn't want. However, if you went to a different domain, you went to google.uk or US or anywhere else or AU, you could still see that information. So that has, the court has then again reinstated that, no, not reinstated, it was the first case before this happened before the international, no, what was it called, right? Yeah, the dynamic injunction we got under this case, the UTV case, this was 2019, but the global injunction we're talking about here in Canada was much earlier. So this was one of the first cases where the court had stated that all the domains that it had internationally around the world, the same information anywhere available had to be blocked. That kind of does bring us to a brief introduction to copyright over the internet. And we move on to domain name. So domain name doesn't strictly fall under the purview of either copyright or trademark, but it has been used synonymously with to mean trademark sometimes and to mean copyright sometimes. It is, yeah, so when there is like google.com, if it is protected, and if there is somebody else using it, of course it is a violation. So for such protection, uniform domain name dispute resolution policy was set into place. Another institute called ICANN was set in, which is Internet Corporation for Assigned Names and Numbers, which is the predominant place, which is the predominant web page to give you to get you to register a domain name. So internet.in, this is another domain name related case. Internet.in was registered by somebody in February of 2005. However, it was registered as a trademark for tobacco and related products in India from March 2003. The respondent here stated that because the names are similar and of course, they wanted internet.in to be taken down and they wanted to be able to use it because they registered it in India. However, the domain name was registered in the US. So the court had to examine if you could struck off a domain name registered in the US and how much effect does it have in India? Is it really being used? And what is the interest of the petitioner? What is the interest of the person who's registered it? Are they using it for the benefit or are they using it only to harass somebody else? And for all of these, the court has stated that the petitioner was in fact using it to harass the applicant herein, because they have registered, he's known to have registered 1747 domains. So starting from internet.com and extending to webpage.com, or all of those really random names were registered by him. So Delhi High Court said that such domain name has to be struck off from the register, and so the registration stands cancelled. However, the respondent, because he did not apply on time, is not allowed to use that as well. So it is not transferred to his name. Very similar result in Tata Sons Limited, the second case on your screen. And Google Incorporated versus Racha Ravindran. So even the same, even in this case, Google.com registered, globally. This Ravinder, however, registered GoogleNetBest.com. So even here it was similarly. Internet patents. So generally, patents are not granted for majority things online, is what we have been thinking. But of late, there are different kinds of patents given because of how things have developed over internet. So, for example, let's say to the scroll, you get to scroll all the things on Instagram, Facebook, everywhere. It's common to wonder if such an act could be protected, because you cannot protect it on copyright. Your web page, how it looks, is protected, but scroll inherently, the idea and the option to scroll is not. You could have a page flick, like how Kindle, the device Kindle, lets you flick pages on it. So like that, you could have a page flick for social media, but it's generally a scroll. So it's not wrong to wonder if such such things could be protected. But what does happen is, when it's a novel idea. So how would you protect it? That's the question. So it's a standard that is set by one person or one part of the industry, and majoritarily there's not much you can do otherwise. So other than the scroll, you have to go up, otherwise you go down, or you swipe right, or you swipe left. So these are the only options you have. If you protect all of these, nobody else would be able to make another application, mobile application. Even for the news applications, most of them are scrolls. So if you protect scroll itself, what other applications can somebody create, and what other features can be added? Because we're still looking at it in 2D. It's not 3D form where it jumps up out of your device and you could change it, right? So such standards are protected under standard essential patents, SEPs. So SEPs are they are allowed to be registered. They are registered, but because it's a standard set by the industry or by an organization, it is compulsory for such SEPs to be given. So licensing of SEPs is supposed to be easier, and prices of such SEPs are set at a stage where it promotes further creativity. It also protects the right of the creator. So all of these are licenses. See, the option to get licenses, to control and to give such licenses, the rates of all of it, these fall under FRAND terms, which is fair, reasonable, and non-discriminatory terms. So it's not an absolute right like the other patents, but it is recognized and it is enforceable. These are some of the examples, actually. So name your price business model. Let's say you have a web page where you say you name your price, and I could let you buy for it. Like bidding is allowed online, right? So online bidding. Priceline.com says they were one of the first to introduce such a business model, and so they demand royalty lately. And same with sitesound.com, who are demanding royalty for online music stores. Artificial intelligence and patents. So there are 5 IP offices around the world: Korean, European, Chinese, Japanese, and US. So these are called the IP5. They handle most of the patent applications around the world. They have set in to try to get artificial intelligence under the purview of protection, and what artificial intelligence creates has to be protected, and creation of it also has to be protected. So they wanted to establish a task force for working of all of this, but more on that later. Um, yeah, protecting the IP on the internet. So how can it be protected? Like we saw, notices and disclaimers. We've discussed that in Lenz's case. She has all the notices that happened there. Watermarks, you see it in all the photographs, everything around all the social media. Cease and desist notices are where, like, the Delhi High Court has given a cease and desist notice. We've just seen that case as well. So all of these are different ways of how you can protect your IP. And in conclusion, there are two basic challenges for IP right administration. One is, what do you want to administer and how do you want to administer it? So both of these are, what do you exactly want to protect? You want to protect the person creating the copyright, or you want to protect the person using it, and or the internet provider who's in the middle of all of this? Because there are more than 5 stakeholders and everything that is linked to the internet. So yeah, what do you want to protect would show path to how you could protect it. And yeah, I think with that we'll stop.
Good evening, ma'am.
Yes, I think with that.
Thank you so much, ma'am, for your interesting presentation on intellectual property rights and IPRs. The lecture was definitely it was a very broad canvas that you drew, and you gave an idea of everything that is possible, and everything that is novel and has changed the ways and means in which we have to actually create or protect IP.
Good evening, one and all. On behalf of DPIIT IPR-Chair Osmania University, I thank the expert for today's lecture, Ms. Sai Bhavana Vemuri ma'am, for the interesting lecture and interaction. I also thank all the participants for the active participation and support given in spreading knowledge on IPRs. I thank you, Professor G.B. Reddy sir, DPIIT IPR Chair Professor, and the team at DPIIT IPR Chair for making this lecture possible. We look forward to meet you again next Saturday for the next lecture. Thank you one and all.